Yes, good afternoon to everybody. So welcome to the class. And this is a Transfer Property Act class, which is the second year first semester course. That is the third semester course, in other words. And if you are hearing me, then you can say that, sir, I could see the what is posted on the screen. Then I could start my class. Yes, Jai Bharati.
Yes, sir.
Very good, very good. And as I told you that if you happen to see the syllabus is concerned, and that is the TPA syllabus, we cover the meaning and concept of the property and the kinds of property. We also cover transfer of property, section 5, transferable, non-transferable property, section 6, who can transfer, the competency transfer, then the operational of transfers. Later we did the mode of transfer. We also did the conditional transfer and condition precedent and condition subsequent. But there is a wide and unlawful conditions are there, where when you say the wide and unlawful condition, that is section 10, section 11, section 2 of the Transfer of the Act will deals about the wide conditions. Later on that we will cover the vested and contingent interest, but in this class we will try to make it out what are the wide contracts are there, what are the unlawful conditions are there, and how it can be made, that we will study in this class. Yes, let us come to the point of the wide contracts are concerned. Yes, I could share on the screen. Could you read it, what I shared on the screen? Yes, anyone?
Sir,
Please read.
conditions conditions restraining alienation alienation under the Transfer of Property Act 1882.
Did you understand all the words? You did not understand any one of the words.
సార్ అంటే కింద కూడా చదవాలా సార్?
నో అడిగింది ఇప్పుడు చదివింది మొత్తం అర్థమైందా మీకు? ఏదన్నా హార్డ్ వర్డ్ ఉందా దాంట్లో?
No, sir. Conditions restraining alienation under the Transfer of Property Act 1882.
What is alienation?
Alienation idea లేదు sir.
Then you did not say that because you said that you know the everything. Restraining means stopping. Alienation means transferring, disposing, and passing the property to somebody else, called alienation. But alienation generally to reset with the selling is called alienation. Disposing the property is called alienation. So there we can make the table of contents. Their introduction I have given. What is the transfer of property according to law, and what can be transferred? Who is the competent to transfer? What is alienation? Can alienation of property be restrained? Type of the restraints. There we can say the two types of the restraints would be there. One is absolute restraint, another is partial restraint. Then the exception to the restraint, lease, married woman position, repugnant conditions, and an exception to section 11, the positive and negative conditions, difference between the section 10 and section 11, condition of insolvency. Later the last part is conclusion. This is the scheme of the study that we will make it out. Let us see what is the introduction given under the wide conditions are concerned. The Transfer of Property Act 1882 is an act laying down the rules and regulations regarding the transfer of property among persons in India. Yes, intra vivos will say the two persons should be there, at least one should be a living one, but another should be either the living person or a juristic personality. In the sense, either it may be the society or the company or the artificial person, either corporate or incorporated, doesn't matter. So we can say the other person is like that. It explains how a transfer property is completed and the conditions under which the transfer may be carried out. An understanding of the basic terms of the Act, along with the exploring the alienation, means here disposing, and its history would be important in understanding the conditions and exceptions involved in the restraint of alienation. So, what is the transfer of property according to law? That we already studied. What is the transfer of property under Sections 5 of the Transfer of Property Act? Has several conditions for an act to be defined as a transfer of property. So, what is the condition says? A living person must convey the property. A conveying essentially means giving a title of the ownership on the property to the transferee. A living person has been defined in the same section to include company, association, or body of individuals, whether it has been incorporated or not. The conveyance of the property can be carried in out both the present and the future. The conveyance may happen towards one or more other living persons, including himself. So, what can be transferred? It is said under section 6, and there are 10 exceptions would be there from A to I, with the double D also be present over there. Oh, those are the exceptions where that property cannot be transferred, but in general, all other property would be transferred. That is what is the section 6 we dealt in a detailed manner in earlier classes. And who is competent to transfer also, that we made it under section 7 of the Transfer Property Act. A person should be competent enough at the time, that is the competence in the sense he should be have the more than the age of majority and have the sound mind, and the purpose of what they are doing is a legal purpose. Other conditions should also be not illegal or against the public policy. If these things are there, then definitely the person is competent to transfer. And this property can be transferred wholly or partly, absolutely or conditionally, with the regard to the extent of the law and circumstances. Either you can transfer in partly also or fully also, with the condition or without a condition, or absolutely also. The property, as stated above, may be conveyed by any living person, including a company, or association, or a body of the individuals, whether incorporated or not. So I told you all that is there should be two living person, and that means the living person in the sense either in the company or the individuals, or the body of the company or body of the individuals, either incorporated or corporated or incorporated within that. Under section 13, even an unborn child can be transfer of the property. Yes, in the further classes that we will see whether the unborn child will get the property or not. So what is alienation? I told you that what is alienation means transferring the property. Alienation means transferring the property. This transfer of the property can be through the gift, sale, mortgages, a lease, or by any other means which we discussed earlier in the earlier classes. Under Hindu law, no person of the joint Hindu family, not even the Karta, has the full power to alienate the joint family or his own interest in the joint family without the consent of all the co-partners. Yes, a Karta should not be supposed to make it out because he has to take the consent unless until there is a necessity is there. At that times he can do so. In the case of the separate property, a Hindu can alienate the property whether it comes to under Dayabhaga or Mitakshara school. This power is absolute. Of course, a Hindu can alienate the property whether it comes under the Dayabhaga or Mitakshara school. The power is absolute at the time. Karta power is absolute. Do you know who is the Karta? Anyone? Yes. Who is the
కర్త
Karta?
అంటే కుటుంబం మొత్తాన్ని నడిపించే వ్యక్తి, ఆయన
Yes.
బాధ్యతలు తీసుకున్న వ్యక్తి.
A key person, generally elder person, who is the first person and who take the responsibility of the running the family is called. Yes. Then becomes earlier under the classical law, the father or the karta had the power to alienate the whole joint family property without the consent of other co-partners, and that is why there have been a certain condition added for the situation where the karta or the father can do so. Of course, earlier the karta would be having the full right to alienate the property in the case of the necessity, but now the rights are changed, but they have to, if the other people are the majors, he has to take the consent of these people also. So that was the position at present, so far my knowledge goes. Yes, can alienation of the property be restrained? So, can a person will restrain the alienation or not? So that is clearly said in the section 10 to 18 of the Transfer Property Act 1888, 82, sorry, that state that the rules for the alienation of property. Let us see what is the section 10 says about the alienation. That section 10 lays down the where the transfer is absolutely restrained. Of here the transfer is absolutely restrained from transferring his interest in this property to another person because of a condition which came along with the property was transferred to the transferee. Then this condition will be made void. The transfer or from the transfer to the transferee would remain valid. Suppose if a condition is put which is said to be the void, at that instance, the transferee would get the transfer of the property, but the condition is void. It is what the section 10 says. For example, it transfers some property. I repeat, it transfers some property to B, okay, as a gift, but with the condition that while A is alive, B must not be transferred the property to any other person. This condition will be held void. So that's why that we will say the void. Whenever the gift is given, you are not supposed to keep any condition because the gift itself is a without any consideration that you are giving. When you are giving the wholeheartedly to the person, at that time, if you keep any such condition, that condition is void, and it is absolutely restrained B from transferring his interest in the property to another person. So that condition is void when it is made. I repeat the same example. A transfer the some property to B as a gift, but with the condition that while A is alive, so long the A is alive, B must not transfer the property to any other person. Means that the gift which is given to the B, you are not supposed to alienate to somebody else or transfer that to somebody else. This condition will be held void. By keeping such a condition is void, as it absolutely restrained because it is completely restrained B from transferring his interest in the property to another person. Suppose if your father, your father is given the car to you. Okay, you take the car, but returning the key with you. Does it mean that he has given the car to you? Yes, give me the answer.
సార్ ఫాదరు కార్ ఇస్తే డజంట్ సార్ క్వశ్చన్ మళ్ళీ రిపీట్.
The father has given the car to you. Okay, but he retained the key with him. The car key.
కార్ కి రిపేర్ విత్ హిమ్ అంటే
రిటైన్ అంటే దగ్గర ఉంచుకున్నాడు. ఎవరు? ఫాదర్. మరి కార్ ఇచ్చినట్టేనా?
నో సార్.
See, whenever he is giving the car, you are supposed to give the key also.
Yes, sir.
Of course,
Car
with the key you can use it. But when you want to really give the form of a gift, better when the car is given over there, better it should be changed the name from the father to the son. Because if any accident happens over there, at that instance, father's insured is there, and the father would be held liable. Suppose if it is not insured. So naturally, when the big items would be purchased and transferred, better it will transfer its title also, but not the pen, pencil, other movable property which have the less value or even the more value also. The oral transfer also you transfer. Yes, that is the what I want to say is, and then this is the commonly known as the rule against the alienability. So, rule against the alienability means who, when a person can alienate it, whether there is any condition to stop it or not. The Transfer of Property Act is based on the principle that there can be a free transfer of property and has been specifically made with regard to free transfer. If conditions restraining transfer are imposed, then the free transfer would be restricted and there would be no use for the Transfer of Property Act. So, if these conditions restraining a transfer is imposed, then there would not be a free transfer. If the restrictions are there, then transfer will not be a valid transfer, provided the restrictions is absolute or partial. Whether the partial is there, okay, it can be done in certain extent, depending upon the nature of the transfer is concerned. But if the absolutely the conditions put it over there, that is becomes a void. So, however, only conditions mandating the absolute restriction are wide. So absolute restrictions are wide. There are conditions which call for the partial restraint to be observed with regard to the transfer of property. Then, if we are to determine whether the condition is absolute or partial, how do you make it out? The condition will make it very much clear that whether the condition is absolute or partial. Then one must look at the substance of the condition. What are the contents of the condition should have to make it out there, and not merely the words. Therefore, the restraints can be classified in two categories. So, how the conditions are there, what are the substance of the conditions, then based on that thing, these conditions are classified into two categories. The type of the categories are number one, restraint, that is the type of restraint. One is absolute, another is partial restraint. Now let us see the what is absolute and what is the partial restraint. When absolute restraints, number one, an absolute restraint is such a restraint which completely takes away the right of the transferee to alienate or dispose the property. The transferee can now no longer transfer his interest in the property to another person, and he has no freedom to do what he wants with the property in his capacity as an owner of the property. Like that example which I have given over there, and the father has given the car to the son, but he retained the keys with him. Whether the absolute power is given, answer is Not at all. Neither he can enjoy the car nor he can transfer the car to anybody else. So that is absolutely that the useless such a gift would be there where you could not use it, where you could not enjoy it if it is given in the by keeping such a condition. Even that is a not valid gift also. The second point clearly says section 10 stipulates that any condition imposed on the transferee, so the conditions are imposed only on the transferee, which would amount to an absolute restraint on the right of the transferee to dispose of his interest in the property shall be void. So if he doesn't dispose the property, neither he cannot enjoy the property also, and such a transfer is useless. Suppose if he enjoy the property, but in the necessity comes he wants to dispose the property, when he could not do so, then the condition shall be void. That condition where he got such a property. The property must be transferred to the transferee subject to the condition. Of course, if there the property must be transferred to the transferee subject to the condition, but the condition should not be absolute condition. The next is in Rocher versus Rocher case law, A made a gift. Just tell you. A Rocher versus Rocher case law. Where is that? Yeah, here. Yes, in Rocher versus Rocher case law, A made a gift of a house to be. I repeat, a person made a gift of a house to be good and gave a condition or keep a condition that if B decides to sell the house during the lifetime of A's wife, she should have the option of purchasing it the rupees 1, 10, 100,000, 10,000 rupees only. While the market value of the house was set as a roughly it is 1, 10, 100,000, 10,000 lakh, 10 lakhs. So the 10 lakhs worth is there and getting the selling the cheaper rate. So this condition was held to be an absolute restraint and was declared void. So one should not supposed to keep it of the lifetime of the wife, okay, but when he wants to sell it, she sell to only to the wife, but not to the other, where the market value is at least 10 times is more than that value is given. So how many zeros are there? 1, 10, 100,000, 10,000 is there. Here 10 lakhs are there. So that much difference would be there at that instance. Such a transfer or condition put on the transfer is a void and hence it cannot be applicable. This condition was then held to be an absolute restraint and was declared void. So when a person has keep a absolute condition at that time, we can say that that condition is void or declared to be void. So that is the happened in the Rocher versus Rocher case law. Let us see the another case law, Kannamal versus Rajeshwari case law, AR 2004. That is the Madras case law. A life estate was to be created in favor of B. I repeat, a life estate was to be created in favor of B, but the transferor gave an absolute restriction along with the property transferred to B. So a transferor had kept the absolute restriction when he was transferring the property to M, while divesting himself for all the interest in the property. The restraint was held to be the void. There was an absolute transfer. So if we keep it certain restriction, at that instant the restriction is a void but the transfer is valid. So, whereas the divesting himself for all his interest in the property, if he put such a condition, the condition is void, but the transfer is valid. This restraint was held to be the void, and there was an absolute transfer. So that was the Karnamal versus Rashwari case law is decided. But you will see the another case law that is Muhammad Raza versus Abbas Bandi BB. That is a case law. A condition imposing a restriction for a particular time or transfer or to a particular person or a specific person has been held to be void. So this condition also be void where a particular time that you put the condition and the transfer to specific person has been held to be void. But a a Parsi community, they can keep such a condition that when they want to dispose their property, it should be disposed only to his community. That is a Parsi only. But other than that, if a person will sell it, that is amount to the void. Such a transfer is void because it is a Parsi community property, hence it goes to the Parsi community only. Yes, anything that suppose in గిరిజన ప్రాంతాలలో భూములు అమ్మితే అది గిరిజనులకే అమ్మాలని రూల్ ఉన్నది. Is it or not?
అవును సార్. అవును.
Because the others are not supposed to purchase it. So because because they are the downtrodden or marginalized people over there. So the conditions put it over there. If you want to sell it, you can sell only to the Girijan, but not to the others. That condition is a not wide. It is a valid condition because the property should not go to the other people. The reason is that if property is given only to those people, hence it should be restricted to those community only. Yes, that is about the absolute condition, which is a void. Then we come to the matter of the partial restraint is concerned. Let us see the what is the partial restraint, how far it can be valid or not valid. Yeah, a partial restraint is a condition. Partial means either 30 to 70% or 50%, 50% or 60-40 or such in such a way we can say it is a partial. A partial restraint is a condition which partially takes away the right of the transferee to dispose of his interest in the property. So here the right is not taken away unsubstantially. The total right is not taken away, but the partially that is taken away. Section 10 does not explicitly talk about the partial restraint. A condition imposing partial restraint is valid. Suppose a partial restraint is made, it is a valid right. Just like I told you the case law just now, a గిరిజన ప్రాంతాల్లో గిరిజనులకి అమ్మాలా, that is the condition which is a partially would be there. ఎవరికి అమ్మకూడదు is absolutely. So it should be, the condition is valid. So now, yes, please ask me.
అర్థమైంది సార్.
Okay, good. So even the Parsi community also, because the total the property belongs to the Parsi community. Hence, if they want to sell the Parsi community, you should sell only to the Parsi, but not to the others. So such a restriction is a valid restriction because it is a partial restriction. Yes, in Mata Prasad versus Nageshwara Sahai, this is another case law. There was a dispute regarding the succession between the nephew and widow. So nephew and widow, who will going to get the succession? So a compromise was formed that a widow had a position of the property where the title for the same was given to the nephew. So here they compromised between the two. Then they say the property title is given to the nephew and with the condition that he was restricted from alienating the property during the widow's lifetime. Okay, even though the title is given to the nephew, but still he could not dispose the property or alienate the property till the death of the widow. So it was held that the compromise and the condition were valid. Yes, compromise is also valid and condition were also valid and prudent in the present case. So that was the, in the civil cases it is a valid compromise. Suppose when come to the criminal cases are concerned, suppose a person has killed another person. So a case is filed over there in the court. Could they compromise? Yes.
నో సార్.
Why?
క్రిమినల్ కేసు కదా సార్.
That is a criminal case. With a criminal case, the compromise will not be allowed over there. Because suppose if you give the 10 lakhs ఇస్తారు నీకు ఉంటున్న గమ్మునుండి కేసు ఫైల్ చేయకురా అంటే అది కాదు. Because the criminal case where the case run by the state, so it cannot be compromised. Because a perpetrator who is a wrongdoer and he should be punished. The punishment is the basic idea in the criminal law. So that's the reason, that is the way we can say. So partial punishment will be allowed over there. Let us see what are the exceptions are available. So when you see the exception to the restraint, number one is lease. A lease is a transfer of property where the lessee only has the right of enjoyment of the property, while the ownership right is still with the lessor. That is called reversionary right. ఏమంటారు దాన్ని? రివర్షనరీ రైట్ అంటారు. When the lease period is over, then the landlord will step into the property of the what property that he leased. Yes, conditions imposing the restrictions are valid in the case of lease, where the condition is for the benefit of the lessor or those claiming under him. In the Raja Janat Ranveer versus the Bagridan, that is the AR 1973, the Allahabad Court 1, a condition is that the lease that the lessee shall not sublet or assign was held to be the valid. So they can keep the condition stating that you are not supposed to, ఇప్పుడే కిరాయికి తీసుకునేవాడు మళ్ళీ కిరాయి తీసుకున్నాడు, మరి కిరాయి ఇవ్వద్దు. I mean కిరాయికి వేరే వాళ్ళకి ఇవ్వద్దు. Yes, such a condition is a valid condition. But he should not supposed to sublet it, given to somebody else when he has taken the lease. unless until the landlord agrees or it brings to the marriage of him, or if he gives the consent, or if it is there already in the contract, then only he can do so. So a lease, a person has taken it, he could not supposed to sublease such a condition. A transferor can keep on the transferee. Is it clear?
Yes, sir.
Very good. So that is the point which I want to make it out. Then we'll say the lease, it is a valid, like what a married woman. When the property is to be transferred to a married woman who is not a Hindu, then Mohammedan and Buddhist, then condition restricting alienation can be valid. Yes, a Hindu woman can sell the property now. Yes, or she
Sir,
should take, a Hindu woman can sell the property now.
సెల్ చేయొచ్చు కదా సార్?
Yeah, provided that property is not in dispute, or provided that property is not the joint property, but it is a common property is there. But suppose the husband is alive, can the wife will sell the property?
No, sir.
He can take the consent of the husband, then he can sell the property also. Either property belongs to him or her, whatever it may be, because both are the person. Especially in the Muslim law, yes, everybody will be eligible there, wife or husband, and there is no distinction of the common property and ancestral property, self-acquired property like that. So the condition is alienation can be valid for the married woman, and she can do so. This is another validity of the condition. So repugnant condition are there. Section 11 of the Act contains the conditions which are inconsistent with the nature of the interest transferred or repugnant condition. These conditions come with the transfer when the transfer confers the transferee about absolute interest in the property. Any condition with a transfer of absolute interest in the property will be void. Of course, partial will be allowed depending upon the circumstances, but the absolute is void. So next point is when the property is transferred absolutely, it must be transferred along with its legal incidents. Yes, that is observed in the Manjusha Devi versus Sunil Chandra in the AR 1972, Calcutta 310. The parties entered into a sale for the piece of land. So here the subject matter of this is a piece of land. In the sale deed, it was mentioned that the buyer could only use the land for setting up a factory for jute textile manufacturing. So the purpose of taking the lease is to keep the jute textile manufacturing factory. That was the idea behind such a sale of the piece of land. It was held that this condition was invalid as the absolute interest in the land had been transferred to the buyer and he could use it as he pleases. So, if you keep the condition that that I am selling this land to you, provided you have to keep only the jute mill over there. No, once that it is transferred over there, whether he wants to keep it the jute mill or he wants to keep the cotton mill, whatever he wants. Even he can keep the flour mill also, because once the property is sold to him, then it is he who can use the property the way he wants or she wants. So that is the absolute nature of the property where the owner of the property. And let us see the word of the exception to the section 11 is if the transferor has another piece of immovable property, yes, he may, for the benefit of that property, impose a condition of the restriction on the transferee's right of enjoyment. Yes, suppose the two properties are there which are adjacent in nature, but the property owner first and foremost only said, but he enjoyed the property. He said, you are not supposed to construct a house. If you want to construct a house also adjacent to my property, leave the, at least 4 yards or 5 yards or so much distance would be there so that he could enjoy his property, a proper ventilation and proper aeration. So that is the easement rights he is having. At the time he can keep such a conditions. So let us see the same example which I now narrated. He has two properties, X property and Y property, and A sells them to B, and with the condition that the portion of X adjoining is Y. Yes, and shall be kept open for the benefit for Y of Y. This condition will be valid. He said, you are not supposed to construct very near to it. Number one. Number two, you are not supposed to make the construction. You have to use it only for the garden. Yes, that he can keep such a condition, because if he raise the building and if he construct a building over there, then there is a hindrance to the air and ventilation these are the factors would be there. So he can put such a condition also. Let us see what is the positive and negative conditions. So a positive condition, these are those conditions imposed on the transfer where the transferor imposes a condition on the transferee to do some act. Like an example, you'll see a transfers land to B. Good. Who transfer is A and the land is the subject matter, transfer is B. On the condition that, what condition that he put, who put the condition? A put the condition. On whom? Onto the B. And who is B? Transferring. That he shall maintain and keep the filling of the well on the plot of land. So that is the condition you will put it, and keep filling of the well on the plot of land. This condition is a positive condition because they are given the thing you have to fill the land, the plot of land every time there is the water. So that is the positive condition. Let us see the negative conditions. There are those conditions imposed on the transfer when the transferor imposes a condition on the transferee to not to do something. That is the example we will see. A transfers the land to B. Good. A is the transferor, B is the transferee, and subject matter is land on the condition that he shall leave open the 4 feet wide space. So he said, you are not supposed to construct immediately after my building because you have to leave the 4 to 5 feet wide space on the land and would not build anything on it. Yes, he can use such a condition because where the two adjacent houses are very close to each other, then the proper ventilation would not be there, proper light would not be there. These are the easement rights which when a person is enjoying, the easement rights will be no more in the picture. So that is the reason they say you leave the some space, then you can construct your house, whatever you want. So now let us see the difference between the section 10 and section 11 is concerned. Section 10 says or specifies that in a transfer with the condition that absolute restraint of the alienation of the property to be by the transferee, the condition will be deemed to be void. Yes, if such a condition would be there on the transferee where the absolute condition is built over there, then such a transaction or the conditions deemed to be the void. Then section 11 clearly says, specifies that in a transfer where absolute right in the property have also been alienated to the transferee and where a condition is imposed that the transferee cannot or in spite of having the absolute right in the property do an act for his enjoyment of the property, such condition will be deemed to void. Yes, even a person who wants to enjoy the property even though his physical strength or physical features allow him to do, but if such a condition is kept over there, then it will be deemed to be void. Then the last one, the difference in these sections are that in section 10, the condition is deemed to be void due to the absolute restraint, and section 11, the condition is deemed to be due to transfer being the absolute nature. So these are the differences we will find in the section 10 and section 11 when they are comparing the absolute condition. Yes. Now the condition of insolvency, let us see that section 12 provides that when the transferee becomes insolvent and if there has some interest in the property that was transferred to him by the transferor, at that instant the transferee still would not lose his interest in the property. Hence, any condition stating the transferee shall lose the interest in the transferred property on the insolvency, and this interest shall not be reverted back to the transferor and shall be void. So this is the condition which is put over there. I repeat, any condition stating the transferee shall lose the interest in the transfer property on the insolvency and this interest shall be reverted back to the transferor shall be void. So it cannot be reverted back to the transferor. Yes. However, this section does not apply to the condition on a lease for the benefit of the lessor or the lease claiming the benefit under him. However, in Smith versus Governor, the Smith versus Gronovo, Gronow, Gronovo, if lessee assigns the lease and then is rendered insolvent, and then this condition will not apply. So here the lessee assigns the lease and then is rendered insolvent. At the time, the condition will not be applied. So some of the relevant cases also I mentioned regarding the Roser, as we did it. Then let us see this the Gayan Ram versus Shahabuddin case law. The sale deed contained a clause that the transferee would not transfer the property to any person, either by way of sale or gift or even the mortgage, except the transferor or his heirs. The court held that this condition was void and therefore invalid. Of course, when the transfer is given over there, then they should not put a gift is given over there. Then they should not say that except what I say, the heir should have to give the acceptance only the gift or is a valid gift. Such a condition will be overlooked because it is said to be not in a absolute manner, it is a partial manner. Then the partial manner conditions will be accepted. Yes, we can have another case law, this Zoroastrian Cooperative Housing Society Limited. Zoroastrians means Parsi people, they are called the Zoroastrians, and District Registrar Cooperative Society. So, a society with the object of constructing the houses for the residential purpose had a bylaw which stated that only Parsis can members of the society. No other person could have to make it out. So, there was also a condition that no member could alienate the house to non-Parsis. If he wants to sell it, it should be sold only to the Parsis. The Supreme Court held that when a person accepts the membership of the cooperative society by submitting himself to its bylaws and places on himself a qualified restriction on his right to transfer the property by stipulating that there would be transferred with the prior consent of the society to a person qualified to be a member of the society, and it could not be held to be an absolute restraint on the alienation of offending the section 10 of the Transfer of Property Act. So here what I want to convey to you is if a Parsi community would be there, if they want to sell it, they have to sell only to the Parsi community, not any other person. Hence you can say in the Parsi community you could not see a man is a poor, or you could not see even Sikh community also a Sikh is begging for the alms. Yes. Then another case law that is Muniswamy, K. Muniswamy versus K. Venkataswamy. This is the case law where a family partition was effected, although one condition in the partition deed provided that the mother and the father are to enjoy the property only during the lifetime, and after their death, this property has to be partitioned equally among the two sons. This creation of the life interest means that the parents had no power to alienate the property during their lifetime. Yes, the parents sold their property to one son, the other son challenged the validity of the sale. The court held that a restriction prohibiting from the absolutely from the transferring the property amounted to an absolute restraint on the alienation and was therefore the bad in the IF law. If the total restraint should be there, then the bad in the IF law. If the partial restraint would be there, it will be allowed. So, is it clear?
Yes, sir.
Very good, very good. So now the conclusion we will see that the Transfer of Property Act 1882 has been made for the regulation of the free transfer of the property in India. This transfer can be in the present or the future and must be between the living persons. Of course, this article also explores what can be transferred under this act and who are the other competent person for the transfer. The concept of alienation was also explored. Earlier, under the classical law, the father or the karta had a right to alienate the joint family property without the consent of the co-personers. But now conditions have been introduced to regulate it. But even the karta could not do so. He has to obtain the permission from the other family members. Yes, section 10, 11, and 12 contain certain conditions under which restraining of the alienation of the property by the transfer are void. It is clearly mentioned, see the void which I highlighted in the red color. I repeat, section 10, 11, and 12 contain the certain conditions under which the restraining of the alienation of the property by the transferee are void. It also has exceptions where these conditions may be valid. Primarily under section 10, condition of the restraint can be classified into two categories. One is absolute, another is partial. An absolute condition is a void and a partial condition may be acceptable. Section 10, condition of the restraint can be classified into two categories, absolute and partial. Whether a condition is absolute or partial is determined by the substance of that condition, not merely the words. This article explored other conditions such as the positive and the negative and the insolvency along with their exceptions. So this is about the round about the today's class regarding the conditions of whether the conditions, the valid conditions or not, or the void conditions are there, or illegal conditions are there that we studied under the section 10 to 11 and 12 of the Transfer of Property Act. Yes, any other questions you would like to ask, you can ask me. Yeah,
No,
because
sir.
this is recorded, then I will stop it, then I will ask you some other big points. So now I will stop the recording so that I can speak